Welcome to EPG Pathshala. I am Vijay Raghavan, Professor in the Center for Criminology and Justice in the School of Social Work at Tata Institute of Social Sciences, Mumbai campus. Today I am going to talk about a module which is called Introduction to Criminal Justice Social Work, which is part of the overall course on fields of practice within the subject of social work. After reading this module, you'll be able to, number one, understand the functioning of the criminal justice system. Number two, understand the role that social workers play or can play within the criminal justice system. And number three, understand how the role of social workers or the social work practice has evolved over time within the space of criminal justice. Social work is defined as a practice-based profession and an academic discipline that promotes social change and development, social cohesion, and the empowerment and liberation of people. Principles of social justice, human rights, collective responsibility, and respect for diversities are central to social work. Underpinned by the theories of social work, social sciences, humanities, and indigenous knowledge, social work engages people and structures to address life challenges and enhance well-being. This is the definition as approved by the International Federation of Social Workers, IFSW, General Meeting, and the International Association of Schools of Social Work, IASSW, General Assembly, in July 2014. Now, when we talk of the criminal justice system, it consists of the following wings. It starts with the police, then the prosecution, the courts, the corrections, which is the institutions like prisons, and the aftercare, which is about the rehabilitation in the post-release phase. The criminal justice system sets into motion when a citizen first comes in touch with the police, either as a victim or as an offender. And once the person comes into contact with the police, then the other processes start, which I have already mentioned, are the prosecution, the courts, the corrections, and the aftercare part. Now, various groups come in contact with the criminal justice system, like accused people, people who have been convicted by a court of law, victims of crimes, then families of prisoners, including especially children of prisoners, then victims and their families, children who are in conflict with law, children who are in need of care and protection, destitute women, homeless people, people who are rescued from any kind of exploitative situation. For example, women who are rescued from commercial sexual exploitation. All these different vulnerable groups come in contact with the criminal justice system, either as victims or as offenders, as well as their families. With a rights-based framework, social workers work towards ensuring the legal rights and rehabilitation of all the groups that come into contact with the criminal justice system. Now, when we look at the criminal justice system, the modern criminal justice system which we have currently in practice in India took shape after the revolt of 1857, because it was only after the revolt that the British administration, the East India Company was handed over to the British Crown, and there was a feeling that there is a need to have a more systematic form of governance in India, because of which the criminal justice system was one of the arms of governance which was developed. It all started with the passing of the Government of India Act, and then gradually the Indian Penal Code in 1860, which is the substantive part of the law, which defines what are the different crimes as defined by the IPC. The Criminal Procedure Code, which is the procedural law, which lays down what is the procedure under which the law has to be implemented, and the Indian Evidence Act, which actually lays down what is admissible as evidence in a court of law. It is these three parts of the law, the IPC, the CRPC, and the Evidence Act, which actually forms the bulwark of the legal system that we follow in India. Apart from that, you also have what are known as special and local laws, which are other laws which have been enacted from time to time because of the different situations that the country has faced. For example, you have the Domestic Violence Act, or you have the Immoral Trafficking Prevention Act, or you have the Juvenile Justice Act. All these are, you have the Narcotics, Drugs and Psychotropic Substances Act. You have UAPA, Unlawful Activities Prevention Act. All these come under the definition of what are known as SLLs, as special and local laws. Now, like I said earlier, the criminal justice system is set into motion after somebody approaches the police or is brought to the police. That is after the filing of the first information report or a non-cognizable complaint. The different components of the criminal justice system is as follows, starting with the police. The police is supposed to enforce the laws, and the main function is maintenance of law and order. Their job also is to investigate the crimes that have been reported to them, either by themselves or by certain citizens or complainants. In recent years, the role of the police has been changing, and today the police is also seen in a larger role of welfare of vulnerable sections of society, and therefore the idea of community policing has also become popular in many parts of the world, including in India. Now, if you look at the hierarchy of the police, in every state, the police department is usually headed by a Director General of Police, who is an officer of the IPS cadre, which is the Indian Police Service. Below the DG Police, there are other positions like the Additional Director General of Police. You could have Additional Director General of Police Training, ADGP Law and Order, ADGP Prisons, different kinds of departments under ADGP. Below that, you have somebody called the Inspector General of Prisons, who is like in charge of a particular range or a group of districts. So you have IG range for Maharashtra, you might have IG Konkan region, or you might have IG for the southern region, etc., etc. Below that is the rank of the Deputy Inspector General of Police, or the DIG, who heads a group of districts and then reports to the IG. The district head, and this is what becomes the most important position in the whole structure, is known as the Superintendent of Police in districts, and in certain states where they have adopted the commissionerate system, that is the metro cities are headed by a Commissioner of Police and the districts are headed by a Superintendent of Police. In some states, they also have a position of a Senior Superintendent of Police for the larger districts. The Superintendent of Police is de facto the person to whom the entire police of that district reports to. So it's a very, very responsible position, and the SP in turn usually reports to the collector of the district. So since the collector is overall in charge of the law and order of the district, so this SP also has to report to the collector. Below the SP, you have the Additional Superintendent of Police, or the ASP. Then the Assistant or the Deputy Superintendent of Police, they head the subdivision in a district. And then the police station is headed by an Inspector of Police. In some states, they are known as Senior Inspector of Police, like in Maharashtra, the police station is headed by a Senior Inspector of Police. Then you have Sub-Inspectors, you have Assistant Sub-Inspectors, you have Head Constable, and then you have Constable. It is the Constable who is really the cutting edge of the police department, because 90% of people come in contact with the constable, and therefore the behavior as well as the actions of the constable is what brings the police either fame or disfame, depends on for the behavior. Then of course, if the constable behavior is not satisfactory, people approach the senior officers, like they would go to a sub-inspector or the inspector in charge of the police station, or they might go to the DYSP or finally the SP, and upper than that too. So the whole system is a hierarchical system. Similarly, when you look at the courts, there are different stages that come up in a criminal trial. One is first is the remand stage. That is when the person is first arrested and produced before a court of law firstly within 24 hours and then till the person is remanded to what is known as judicial custody or jail custody, the person continues to remain in police custody. And this is usually for a period not more than 14 days. So this is called the pre-trial stage or the bail stage, this is also the stage when the trial has not yet started. Now when I say trial has not yet started, it means that the police has not yet submitted the charge sheet, and after submission of the charge sheet, the stage next is called the framing of charges. And when the charges are being framed, that means the magistrate or the judge will ask the accused that these are the charges against you, do you plead guilty to these charges? If the person says yes, I plead guilty, then there is no trial, then immediately you move to what is known as the sentencing stage. But if the person says I do not plead guilty, then the trial starts. So this is called the trial stage. So you have a pre-trial stage and you have a trial stage. And usually the bail is asked for in the pre-trial stage. In terms of the functionaries in the court, you have the magistrate or the judge, depending on the severity of the offence. The matter will either be heard in a metropolitan court in metropolitan cities or a judicial magistrate first class in the district places. And in serious offences, they would be heard by a sessions court judge. So you have the magistrate or the judge, then you have a public prosecutor whose job is to collect the evidence and present it before the court. And the public prosecutor is somebody who actually is trying to prove that the accused is the person who has actually committed the offence. You also have the defence lawyers whose job it is to ensure that the accused person gets fair amount of justice and there is somebody to represent his or her side of the story. Legal aid is a constitutional right, and therefore if a person cannot afford a lawyer, then the defence lawyers will come into place from the State Legal Services Authority. Every State Legal Services Authority is divided into District Legal Services Authorities, and it is the DLSAs which provide the lawyer from the legal aid panel of lawyers. In terms of the hierarchy of the judicial system in India, at the top is the Supreme Court of India, which has three types of jurisdictions. One is original jurisdiction, second is appellate, and the third is advisory. Original is that kind of jurisdiction where these matters directly come to the Supreme Court. It does not come as an appeal matter. For example, writ petitions, which are filed, also known as public interest litigations. This is the original jurisdiction of a Supreme Court. I, as a citizen of this country, feel if my fundamental rights are being infringed upon, I can go to the Supreme Court and file a writ petition, and the Supreme Court will hear my case if they find substance in the appeal. Then the appellate jurisdiction is when a matter goes in appeal, usually from the High Court. So if a person has been convicted, for example, he will first be tried in the lower court. Then from the lower court, the matter will go to the Sessions Court. From the Sessions Court, it will then go to the High Court, and finally it will go to the Supreme Court. Now this is depending on the aggrieved party. If the aggrieved party, could be the state or could be the accused person, wants to appeal, there is a period within which you can appeal and the matter can go up to the Supreme Court, which is the appellate jurisdiction. Finally, you have something called the advisory jurisdiction, where the government of India can refer certain matters to the Supreme Court, asking for its opinion in terms of what can be done in a situation like this. These are usually constitutional matters. Then you have the High Court, which is the highest court at the state level. This court also has both appellate and original jurisdiction, but it does not have the advisory jurisdiction. At the district level, you have, like I already said, there are two types of courts. One is the Sessions Court, which again has both appellate and original jurisdiction. Certain kinds of cases only come directly to the Sessions Court. For example, a case of murder would not be heard in the Magistrates Court. It would go first directly into the Sessions Court. And then below that you have the Judicial Magistrate, first class, or the Metropolitan Magistrate in metropolitan areas. So the simpler offences get heard by the Judicial Magistrate or the Metropolitan Magistrate. You also have Judicial Magistrate second class, who deal with petty matters which are not imprisonable offences, where there are fine sentence cases. And then you have executive magistrates, usually the district administration, who decide on certain non-criminal matters. Now, when it comes to the corrections or the the institutional settings, so what is happening is, first the person is being brought to the police station. From the police station, the person is being taken to court. From the court, the person finally, if convicted, is sent to the prison, or even if he is under trial, he or she is sent to the prison as an under trial prisoner. And this is where the correctional institutions are set into motion. Correctional institutions would largely be prisons, other kinds of correctional institutions like protective homes, children's homes, beggars' homes, a whole lot of institutions which are meant for either penal custody or protective custody. A penal custody is prison, and protective custody is the other institutions that I just now mentioned. Inside these institutions, you have vocational training, you will have counseling, you have some kind of education facilities, you would have civil society involvement in the form of NGOs coming inside and doing some work. You may have field action projects of universities. For example, TISS has a number of field action projects which are working in the correctional agencies. So this is the kind of work that may happen. In terms of the jails that we have, or the prisons or correctional institutions that we have, you have central prisons. What are central prisons? Those prisons which house population beyond a certain number. So if the population is more than 500, for example, it would be termed as a central prison. District prisons are those which house up to between 250 and maybe 500, and different states have different numbers in terms of, but basically a district jail houses fewer number of prisoners, and usually the district jails do not house the convicted prisoners. It is mostly the central jails which house the convicted prisoners. At the same time, I would also like to clarify that there is no hard and fast rule of that sort. You do have district prisons where you have convicted prisoners. Then you have the sub-jails, which are the really small jails, and in some cases these are the jails where people are kept for a very temporary period till they are transferred to a district jail or a central jail. You also have specialized jails like special jails for women, where women from a particular region would be kept in a central location so that you can have better facilities for them. Though there are also some disadvantages of doing this, because then women get separated from their families because the distances become very far. You also have system of open prisons, whereby prisoners who have completed a certain part of their sentence are then transferred to these prisons which don't have any walls, and the escape rate of these prisons are extremely poor, which shows that that you don't necessarily need high tall walls to keep people in prison. If the person has no motive to escape, then he or she will not escape. Most of these open prisons are for male prisoners. There are very few open prisons for female prisoners. You also have open colonies whereby prisoners can live with their families. So like for example, you will have a large agricultural land, and in that area you will have small quarters, and the prisoner will be living with his family in those quarters. He will go out to work in the morning and come back before 7 o'clock, and if he doesn't come back, then it's treated as an escape. And whatever money he earns, with that money he can run his family. Now this is a facility which is available to only that category of prisoners who have shown very good behavior and conduct when they were initially in prison, and it is only open after a certain period of imprisonment has been completed. You also have something called Bostel schools. This was a system that we have borrowed from UK, because anyway the entire criminal justice system in India has been borrowed from the Anglo-Saxon legal system. These are institutions for youth offenders for their rehabilitation and retraining. So these are totally focusing on vocational training activities. This is as far as the adult criminal justice system is concerned. You also have the juvenile justice system, whereby you have observation homes for children who are in conflict with law. You have shelter homes and children's home for children in need of care and protection. You have protective homes for women who have been rescued from commercial sexual exploitation, and you have beggars' home for people who have been arrested for beggary purposes. We have a law in this country where begging is an offense. When we look at the criminal justice process, it is largely today governed by certain human rights and certain constitutional provisions. When we look at the human rights part, the most important one is, of course, the Universal Declaration of Human Rights, which was passed in 1948. Then you have the International Covenant on Civil and Political Rights. You have the International Covenant of Economic, Social and Cultural Rights, the Convention on Elimination of All Forms of Discrimination against Women, the International Convention on Elimination of All Forms of Racial Discrimination, and the Convention on the Rights of the Child. Of course, also the Convention on Torture, against torture. All these UN conventions have given a broader framework to understand the fact that when you're talking about people who are brought into custody under the criminal justice system, they have certain basic human rights which cannot be denied to them. In particular, with regard to prisons, I would like to mention the UN Standard Minimum Rules for Treatment of Prisoners, 1955, which lays down basic conditions under which every prisoner has to be kept, including food, clothing, shelter, visiting rights, basic other facilities, relationship with family, separation of male with female, adult with child, etc., etc. Now, when it comes to the Constitution of India, some of the provisions of the fundamental rights which we really need to look at, which kind of give a context to this whole criminal justice system, is firstly the right to life and personal liberty under Article 21. The right to freedom, the different freedoms that are given to us as citizens under Article 19, the right to equality, which is from Article 14 to 18, the Article 14 which talks about protection, equal protection to everyone before law, protection from arrest and detention in certain cases, which is Article 22, and Article 39A, which talks about equal justice and free legal aid. The process of the criminal justice starts with the arrest, which is laid down in Chapter 5 of the Criminal Procedure Code. Any arrest has to be first justified by law, and it has a set procedure in terms of issuing of warrant, reasons for arrest, family member to be informed at the time of arrest, production before the court within 24 hours, medical examination every 48 hours, and prohibition of torture. All these are laid down in what are known as the D.K. Basu guidelines, which is a Supreme Court decision taken in 1997, AIR 1997 SC 610, and this is a very important decision which has now been incorporated in the law in the CRPC. It also lays down clear identification and name tags should be there on the arresting officer and the preparation of the arrest memo. Then after arrest comes the bail stage. Now bail can be of three types: cash bail, surety bail, and release on personal bond. There are some very important Supreme Court judgments here again. The birth of public interest litigations has come from here. There is the very famous Hussain Ara Khatun and others versus Home Secretary, State of Bihar in 1979, which set for thousands of under trial prisoners released on personal bond. Recently, you have amendment in the CRPC section 436 and 436A, under which if somebody has completed at least 50% of the maximum sentence that he would have got otherwise, the person can be released on personal bond. Or if somebody has already been granted bail and more than 1 week has passed, then he should be considered as indigent and the person should be also released on personal bond. When it comes to legal aid, like I already said, there is the National Legal Services Authorities Act 1987, where legal aid is a right from the first stage of arrest at the police station. The trial process, firstly the charge sheet has to be filed by the police within 60 or 90 days depending on the type of case. The case is first heard by the judge or the magistrate. Then there is the prosecutor who will present the evidence against the person, who will also examine the witnesses. The defense will also present their evidence as well as cross-examine the witnesses. Both sides of witnesses would be cross-examined by both parties, and then finally it will lead to pronouncing the guilt or the acquittal of the person, including discharge in certain cases. Difference between acquittal and discharges. Acquittal is a person has been found not guilty. Discharge is a person has been discharged because of lack of evidence. After conviction, then the sentencing stage starts, and when the person has to be sentenced, again there will be prosecution and defense laying down arguments in terms of what should be the sentence, and then the judge would finally pronounce the sentence. There's also the concept of victim compensation, which has been brought in under section 357 ABC of CRPC, and state governments have come up with their own schemes for victim compensation. For example, Maharashtra has come up with a Manodharya scheme where rape victims can get up to 3 lakhs of rupees. Now, when we look at the historical sketch of social workers in criminal justice system, the first juvenile court was set up in the United States in 1899 in Illinois, and the first organization to assist abused women was established in 1885. By 1900s, police women had begun providing social work services in police station. If you look at the Indian scenario, the first reform movement starts with the Indian Jails Committee report in 1919-1920, but nothing much came out of it because the recommendations of the jail committee was not implemented. Then you had the coming of the prisoners' aid societies, which were established in the pre-independence period. The probation officers under the Probation of Offenders Act, which was passed in 1958, which provides for community-based treatment of offenders, and aftercare homes for many of these released prisoners. In the post-independence period, the most important person that we need to talk about is the American criminologist and the United Nations correctional expert, Dr. Walter C. Reckless, who was invited to India to help lay down the correctional policies in India. Through his efforts and another UN expert called Dr. Edward Galloway, the first training program for prison officers and correctional officers was started in 1952 here in the Tata Institute of Social Sciences. Then the formation of the Central Bureau of Correctional Services was recommended, which was later renamed as the National Institute of Social Defense. The first MA degree program for government officers in the field of corrections was organized here at TISS in 1952, and from then onwards, many government officers like jailers, welfare officers, social welfare workers, probation officers came to TISS to do their masters in social work with specialization in criminology and correctional administration. Gradually, the entry of social workers into the criminal justice system was brought in through the juvenile justice system, where social workers became an important part of the juvenile justice system as probation officers. Also, many field action projects were started here at Tata Institute. For example, Prayas, which works with prisoners and women rescued from commercial sexual exploitation. The Special Cell for Women and Children, which works with violence against women victims. Resource Cell on Juvenile Justice, which works with juveniles in conflict with law. Koshish, which works with beggars' homes and people in destitution. And Tanda, which works with denotified tribes. Okay, so just to sum up, what we have tried to do through this module is, one is give you an idea of what the criminal justice system is all about, the historical development of the criminal justice system. Then we have talked about the different wings of the criminal justice system in detail in terms of the structure, the hierarchy, the functions, the role, etc. Then we have talked about the history of social work practice within the criminal justice system, first in the West and then in India, what kind of developments took place, and what is the current status of social work intervention in criminal justice in India today. Thank you.